I am so thrilled to have you here today because we're going to be looking at a truly fascinating piece of source material. It's a text that literally upends standard legal playbooks, making it this incredible case study in how history is actually recorded. Today, we're going to impartially unpack a dense, highly charged forensic historical analysis by Kanwar Partap Singh Gill. It's called The Confession as Indictment. Now, Gill's text examines the trial and execution of Bhai Harjinder Singh Jinnah and Bhai Sukhdev Singh Sukha, and it fundamentally challenges how legal records and historical memories are constructed. So let's just dive right into this.
To hook you right in, we really have to start with the central legal mystery of this trial. Think about it. How exactly do you secure a capital conviction, a death sentence, when the prosecution's independent evidence practically falls apart? I mean, in this explainer, we're looking at two men who formally pleaded not guilty in a court of law, but then simultaneously provided incredibly detailed, voluntarily given confessions that ultimately secured their own death sentences. It sounds completely contradictory, right? But Gill's analysis lays out a very precise, deliberate logic at work here.
And this brilliant tension is really the core of today's explainer. We're going to objectively explore how the state and the accused viewed the exact same series of events, but through entirely different moral and legal frameworks. So from the state's perspective, this was just a clear-cut case of criminal guilt and a broad conspiracy. But from the accused's perspective, well, their not guilty plea was actually a jurisdictional objection. You see, they were operating under the theological concept of dharam-yudh, which translates to righteous struggle. In this specific context, that meant they weren't merely mounting a standard criminal defense, they were actively challenging the state's legitimacy. They weren't denying the facts, rather, they were denying the state's moral authority to even judge them in the first place.
To make sense of this unprecedented trial, here's our roadmap for today. 1. Roots of the conflict. 2. 1984, assaults and massacres. 3. The accountability campaign. 4. A uniquely paradoxical trial. And 5. Two judgments of history.
Section 1. Roots of the conflict, broken promises, and federal demands.
So to truly understand the events of 1984, Gill's analysis reveals that we actually need to rewind all the way back to 1947. According to the text, the Sikh community joined the Indian Union based on unfulfilled promises of regional autonomy. Over the years, by 1973, this evolved into the Anandpur Sahib Resolution. Now, this was essentially a constitutional demand for state federalism. We're talking about things like water rights and capital city designations. However, the forensic historical record points out that there was a deliberate government strategy to recast these constitutional federal demands as dangerous, separatist sedition. Through media and political rhetoric, these demands for states' rights were basically labeled as threats to national security. And this reframing, the source argues, completely shut down political negotiation, setting the stage directly for the devastating military intervention of Operation Blue Star and the subsequent massacres in 1984.
Section 2, 1984, Assaults and Massacres.
80. The forensic record draws our attention to this very specific number to document the sheer scale and intentionality of Operation Blue Star in June of 1984. For context, this was the military assault on the Golden Temple complex, which was commanded by General A.S. Vaidya. The text details how the Indian Army deployed tanks and fired roughly 80 artillery main gun shells directly into the sacred Akal Takht, which is the institutional expression of Sikh temporal sovereignty. Crucially here, the author uses military and historical records to emphasize that this assault was launched on a major religious holiday, the martyrdom anniversary of Guru Arjan Dev Ji. The state's awareness of this holiday guaranteed a massive presence of unarmed pilgrims, and the source argues this deliberately led to catastrophic mass civilian casualties. And the violence didn't end in June. Following the assassination of Prime Minister Indira Gandhi in November 1984 saw widespread violence against Sikhs. But the source is incredibly precise about this. It describes these events not as spontaneous riots, but as highly organized massacres. Civil liberties investigations revealed a truly chilling level of coordination. For instance, electoral voting lists were systematically used by mobs to specifically identify Sikh households. Kerosene was pre-positioned and distributed to these mobs. And the text highlights a key detail here. Kerosene was a rationed state resource at the time, so its abundant pre-positioning is a glaring indicator of state complicity. Furthermore, local political offices actually functioned as organizational hubs, proving, according to the article, that this was a planned pogrom that actively utilized political infrastructure.
Section 3. The accountability campaign.
Okay, so to understand the response to these catastrophic events by Bhai Harjinder Singh Jinnah and by Sukhdev Singh Sukha, we have to look at another number, 227. Following the November massacres, independent civil liberties organizations published a report that became known as the Black Book.
It explicitly named 227 individuals, including very powerful politicians, who were identified by survivors as organizers of the mob violence. But here's the profound institutional failure the author points out. The state completely ignored this evidentiary record. There was not a single immediate prosecution for those 227 organizers. The source argues that this exact, deliberate failure of the state to provide lawful accountability is what directly motivated Jinda and Suka. They launched an accountability campaign targeting specifically protected figures, like General Veda and those unindicted politicians. And they viewed this through that theology of Dharma youth, a righteous struggle that you only take up as an absolute last resort, when all other institutional avenues of justice have been systematically closed off.
The 1987 Ludhiana Punjab National Bank heist is a perfect illustration of their operational code. Jinda and his associates executed the largest bank robbery in Indian history at the time, securing over 5.7 crores to fund their movement. But here is the striking forensic reality of that day. 0 bullets were fired and 0 blood was spilled. Not a drop. The source uses this to deeply contrast the state's label of them as indiscriminate terrorists with their actual, on-the-ground operational discipline. They operated under a very strict military code. They drew their weapons only against specifically identified figures tied to the events of 1984. Actually, they went out of their way to actively choose not to harm civilian bank tellers, guards, or bystanders.
Section 4. A uniquely paradoxical trial. So according to the Supreme Court record cited in the article, the state's independent evidence actually fractured and collapsed during the trial. The prosecution tried to build this massive case around a broad conspiracy theory, but the courts outright rejected it. The direct eyewitness identifications that supposedly placed the men at the scene, thoroughly dismantled during cross-examination and ultimately deemed frail and inconsistent. Even the state's handwriting expert was labeled subjective and uncorroborated by the highest court. In any normal criminal trial, this kind of total collapse of independent evidence would typically lead to a complete acquittal. On its own, the state's independent case was likely nowhere near enough to secure a capital conviction. And that is exactly what makes what happens next incredibly extraordinary.
Which leads us to the most fascinating mechanical aspect of this whole explainer, and what makes this trial entirely unique in Indian legal history. It revolves around Section 313 of the Code of Criminal Procedure. Now, normally, this is just a procedural safeguard. It's simply an opportunity for a defendant to say, hey, I wasn't there, or the evidence is fake. But Gill's analysis shows how Jinda and Suka utilize this legal instrument for something completely different. They actually bypass their own defense lawyers. They repurpose the state's own procedural tool, not for a standard criminal defense, but to speak directly to the historical record, formally documenting their theological motives and essentially building a permanent archive. In their Section 313 statements, they provided these incredibly detailed, unambiguous admissions. Maine Vaidya ko mara hai. I killed Vaidya Sahib. This is the dramatic admission that ultimately secured their conviction. But by admitting exactly what they did, while formally refusing to plead guilty, they were executing a profound jurisdictional objection. By placing their detailed theological reasoning firmly on the legal record, they were effectively putting the state on trial for 1984. They reversed the roles of accuser and accused. They were basically telling the court, look, we admit to the act, but we refuse your moral authority to judge us as criminals, because your state shelled our sacred throne and protected mass murderers.
Section 5. 2 Judgments of History.
The text impartially presents this stark timeline to visually highlight what is a massive disparity in institutional priority and speed. The state utilized special designated courts known as Tata courts, which were meant for rapid trials, to convict and execute Jinda and Suka in just 6 years. Conversely, when you look at the political organizers of the 1984 massacres, the men who were explicitly named in that black book and who were primarily tried in standard courts, the speed is entirely different. They benefited from decades of endless delays. Sajjan Kumar was convicted after 34 years, and for Jagdish Tytler, charges were only formally framed after 40 years. The author uses this data to argue that, hey, this isn't about mere institutional incapacity. It reflects a deliberate institutional priority and a stark judicial asymmetry.
Which brings us right to the author's core thesis on how history remembers them. Yes, the state got its capital conviction and issued the sentence. But by voluntarily submitting their incredibly detailed 16-page theological reasoning through the Section 313 procedural instrument, Jinda and Suka legally forced the Supreme Court to record and engage with their argument. They forced their confession and their indictment of the state's transgressions into the permanent official historical record of the Republic of India. So the prosecution won the case, sure, but the accused built the archive on their own terms. History remembers them uniquely because this very document became a foundational text for the community's historical memory, permanently bypassing the state's official narrative.
And that leaves us with this final, truly provocative thought from the source material. When the official legal record of a state and the lived historical memory of a community tell two fundamentally different stories about the exact same events, which one ultimately writes the final verdict? It's a fascinating look at how justice, memory, and history intersect. Thank you so much for joining me for today's Explainer. I really hope this breakdown helped bring some clarity to a highly complex and deeply impactful piece of historical analysis. Until next time, keep questioning and keep learning.